Good morning, friends. Namaskar, Sat Sri Akal and Adab. This is my 192nd video and it will cover a case from Belgaum Cantonment on resumptions. This case number 494, date of decision 27th November 1957, and the bungalow concerned was number 59, survey number 198. So I'll just brief the first court findings. This was a resumption notice plus on tenancy this bungalow was hired by the MES given on 15th February 1952 under breach of grant. So the cause of action rose after a notice was given by the bungalow owner and CPC 80C. So the MES stopped paying rent from the date of resumption, that is 15th February 1952. There were various documents which were attached. The Cantonment Land Register for Bungalow Number Exhibit 90, admission deeds of Ramzoo, Yamo and Meenubai as Exhibit 82 to 93. There's another very important letter of 1952, Exhibit 43, where the MEO is admitting that they have no documents of grant. Exhibit 52, it is a general land register maintained then by the Cantonment Magistrate, leaving column E and J blank. They were empty. Exhibit 80 is showing the general land register where it is mentioned it is a B3 land. And then Exhibit 83 and 87 which says GGO 1832 number 99 of 2nd March is applicable from Bombay Presidency. Pages of Military Land Manual 1937, page number 255 speaking of Rule 3, Sub-Rule 3 and 1. So friends, my immediate request in Belgaum Cantonment is dig into this judgment. It is not a very old judgment. I have records from Ambala from 1876. So go to the judicial record room and dig into this order which I just mentioned and you will get various. Now what is this case? In 1957, Shri Viragoda Desai, he was about 36 years of age, living outside the bungalow and in somewhere in Tilakwadi Belgaum. He filed a suit against Union of India. So his basic pleading made by the owner or the HOR is, plaintiff sues to recover possession of the suit property described in para 1 of the plaint, together with rent and damages for use in occupation as detailed in para 4 of the plaint, along with future means profit and cost of the suit. He also prayed for declaration that the resumption order issued by the defendant is illegal, ultra vires and not binding upon him. Now when the present owner purchased this bungalow from Ramzoo Seth and his family way back on May 1949, it was already in possession of the MES. They were on hire. Interestingly, the MEO even started paying rent to this new owner, Mr. Desai, V. Desai, without mutating his name in the GLR, even without having an admission deed from this bungalow owner. Now the new owner kept asking for occupation of the possession of the bungalow since that lease agreement signed between then in 1919 and the predecessor had expired. 1955 he even issued a notice under section under CPC 80, but nothing in turn came out. So in return the MEO now writes, since you are in breach of the grant terms, and on 26th April 1952 the owner was asked that the bungalow should be resumed because since it is held on old grant terms as per the GLR. So finally a resumption notice was issued on 12th November 1954. For what? For breach of grant. And the compensation offered was about 16,714 rupees for the built up area. So owner replied this notice and he replied it on 2nd February 1955. It's very important. So the cause of action between him and the present owner BD Desai now, V Desai had, because he was 36, and Union of India has already resumed. So the relation of the landlord and tenant ends as per the Bombay GGO of 1827. So the same bungalow can be resumed. This is what the MEO Bombay Pune is writing. So on these plea, what the plaint and the written statement came from the MEO or the Union of India, issues were made as Exhibit 13. First issue was on resumption order, whether illegal. Does the defendant prove his title to the building? Does the plaintiff entitled to its value only? Is the suit in time? Is the notice of suit valued in law? Has the plaintiff paid proper court fees? 7. Whether the plaintiff requires the suit premises for his personal occupation with bona fide intentions. Whether the defendant is stopped from putting forth his claim over the building before surrendering possession to the landlord, that is plaintiff, and what order. So, well, let's go into the nitty-gritties of this case now. This case is with me, given by Miss Nancy when I visited Belgaum. What is the evidence led in by either of the two parties? In oral evidence, plaintiff examined himself at Exhibit 28, and in documentary evidence, he produced all 35 documents with 5 lists, exhibit number 3, 14, 27, 30, 55. So these many papers are there. On behalf of defendant, 3 witnesses were examined in oral at 56, 63 and 68. Various documents were filed, about 15 by the defendants, ranging from exhibit 18 to 65. Facts of the property. This suit property, bungalow number 59, originally belonged to one Ramzoo Abdul Latif. And on 5th May 1949, the plaintiff purchased this property for 35,000 rupees from the above named man. Now the property was already in possession of the defendant as per Exhibit 41. After the purchase, the defendant even started paying rent to the plaintiff, and they were paying this rent from 17th December 1915. So, what was this sale deed? On 1949. So, to date, that is 1954, number of letters were exchanged between the new owner, Mr. Desai, and the defendant, that is the MEO Pune, but regarding the possession and derequisitioning of the property. So the new Bombay Tenancy Act number 57 of 1947 was repealed, and another act was made in 1957. Meaning that since 1919, this bungalow was on hire. Friends, this is a very important case. If I am able to get the 1919 lease, I will change the entire scenario of this property, because this bungalow must have been on hire under the House Accommodation Act 1902. But unfortunately, bungalow owners and we don't want to share our documents. We don't want to talk to each other. Now, what does the law say? That all lands, including the cantonment, are government properties. Private persons occupying any portion within the cantonment's limit cannot at any stage be given proprietary rights. All cantonment properties are governed by army regulations. The rules there under volume 2 is governed by so and so rules in appendix 4, rule 30 and 35, where the transfer to anybody or in especially to a native cannot be done with the previous sanction of the commander-in-chief. So the government, and then you have to give an admission deed. Well, these rules don't speak this. But yet the government pleader is pleading. He referred to the General Land Register, which is a public register under the cantonment laws maintained. According to Rule 3, Exhibit 90, the copy of the register, the pleader is fully playing reliance on it and saying that this is a B3 land. and on old grant terms as per the HOR column there. So the pleadings here become very important as the government pleader is stating a lot of army regulations. He is saying no sale can take place without permission. GLR, he talks of Exhibit 90 where it is written B3 lands. Now here plaintiff's counsel in 1957 was unaware of the Jepson's Code 1850, was unaware of the Atchison's Code 1836. Neither did he argue when was B3 as a classification given, when was the GLR made for Belgaum Cantonment. So simply, when our lawyers or our counsels are unaware of these laws, yet this case was fought very well. So these points could have been argued because till the CLA rules 1925 and 37, these things were there in place, but in 1957 he didn't. So admission deeds taken by Ramzoo Sethi and her sisters Yamo Bai and Minu Bai, who were not even declared HOR as, because they were not the purchasers, they were the inheritors of Bungalow number 59. So here the government pleader is saying that the admission deeds were asked why. He doesn't know. So there is no argument in pleading on this point. Here there are two people, Mr. Kale from the DO office or the MEO and Mr. Kutur from the CO's office. So what has the evidence led? That except the admission of Ram Abdul Latif, plaintiff's vendor and Yamo Bai and Mino Bai, there is no record to show that this land was given or granted on lease to whom at the time when these entries in Exhibit 90 were done. Very clearly Mr. Kale is by himself contradicting his own GLR. Even the entries in Exhibit 52 are found to be incomplete. How? As column E and J are left blank. So this document, which was the original GLR of 1925, is very important in this case. So entries in other columns might have been what the observations are on the arguments be filled to fill up this case's doing. So that Exhibit 49, the GLR maintained by the Cantonment Magistrate, becomes very important. Then he goes on to state he is denying his knowledge to any material question put forward to him in cross-examination. Finally, he has stated on page 6 that he does not know if any record to show that original grant anything of the government and whether the grant was registered anywhere, whether the previous owner took any permission to construct the bungalow, so on and statements. So he is practically denying all questions put to him by the counsel. So this becomes very important. His evidence needs to be brought out. Here now Mr. Kutir from CO states that the admission deed which he is tendering was actually typed by him by an order of a senior officer or a clerk, and it was neither registered, neither on stamp paper. So he doesn't know why it was made. Now when the arguments were being pleaded, Union of India very clearly, their counsel brings in the complete compendium of Mehta Committee report for Belgaum and Pune Cantonment and argues that Belgaum Cantonment has got its own history, which has been elaborately put up in Mr. Mehta's report. Though there was no opportunity for the other side to make any comment on this report, yet the order to find out the exact situation, my lord says that he went through this entire report and certain exact positions of the suit property, bungalow number 59 in this report, which rather is an exhaustive document. I find on page 42 in para number 4, under the heading Cantonment Statement number 3, the order which I have mentioned in my Belgaum report. So this suit bungalow number 59 is included in a group of bungalows. The holder which had passed acknowledgement admitting the cantonment conditions and the tenure again on page 52 at serial number 79. Who was the owner then? Ram Narayan Jai Narayan Sharoff. Passed and an agreement to abide to the conditions in respect of bungalow number 43, 59, 90 and 135. So at least these 5 bungalow owners get together, dig into this record And then finally there were some miscellaneous file applications. This is very important, file of 1884 of Belgaum Cantonment, magistrate on page number 16, the current entries of number 66, 67 and the correspondence regarding repairs of bungalows of 1903 and 1904 can be found. There is a conservancy file number 71 of 1902. There is another correspondence file number 117 of 1904. So we can all do this if we want. My Lord states in this case, Union of India has not produced enough evidence for the same case and they relied upon two documents, admission deed and GLR alone. Second observation, my Lord says, on these materials from Mehta Committee report, it is quite clear that the defendants could have produced sufficient record to throw light on exact position and tenure of the suit property. The record, if produced, would have helped this court in arriving to a definite and correct conclusion. But I do not understand why the authorities have held back the relevant files and necessary important documents. Even till the last moment, the only reasonable person, Mr. Kale, who was examined before me and on behalf of the defendant, also repeatedly kept stating that there is no record to throw light on the suit property. So these documents could have been produced at the right time. My Lord, in the third observation, goes on to state that the admission deed given by Ramzoo Seth and her sisters was not stamped, neither it was registered. It was a typed document. So, and since it is said that the admission is to be only taken when there is a sale or a transaction having between the properties. So, he clearly says this admission carries no relevance either. Here I feel in 1957 there was a change in the Ministry of Defence executive order that from now onwards that the admission deeds will be registered and the draft of the sale deeds will be approved by the MEO or the DOs then. So here the learned district pleader even cites the famous case of Ghaswala versus Secretary of State India, Pune. He even cites the other case of Hirachand versus Secretary of State, where clearly they are showing that lands within the limits of a cantonment belong to government. But here they could not produce any plan, any survey map. Neither like in Ghaswala they produced the HSN report or the Jepson code. Nothing of this could be produced. So coming to the resumption procedure in 1957. Now the arguments are stated. Resuming a property has to be followed laid down in a procedure of Military Land Manual, page 255 under Rule 3, Sub-Rule 1. It clearly states that there has to be a sanction from the central government in Subclause 2. So where is that sanction in this case? The resumption notice is a notice. It is not an order since the central government has not given a sanction. Second, the argument what the plaintiff makes, further it is argued that the behalf of the plaintiff that the MEO is authorized to sign the notice of resumption as laid down in an order dated 1st September 1938 on page 256 of Military Land Manual, Exhibit 36. So the defendant calls that this notice issued to him in 1952 is just a notice. It is not an order of resumption since the sanctioning of the Government of India has not come. So on these two very arguments, the notice and the difference between a notice and an order of resumption is bifurcated. Knowing that the now friends, this is the most important concluding arguments which the plaintiff is making. He is making a kind of argument on discrimination within Belgaum Cantonment. Let's say in Belgaum, as per Mehta Committee report, there were some 153 bungalows. Now in 1957, he says, many bungalows have been released which were on hire by the government or the Ministry of Defence, Union of India. and his alone bungalow was not derequisitioned. So he's mentioning all this. And these all bungalows which are yet on hire or on illegal possession of illegal occupiers who have not taken permission for sale are near the parade ground, he's mentioning. He's giving a list. Why are those bungalows not being resumed or why are they being released? So the plaintiff clearly argues the military authority is discriminating between him and other bungalow owners 53 in the cantonment of Belgaum. So this is enough to show that discrimination. The plaintiff mainly refused to give admission, now he says, in favor of that this land and everything what was the subject. That is why the MU or the local authority, their army, was up arms against him. And they did not want to derequisition the property, so they went in for a resumption. And they even went on to threaten this bungalow owner of dire consequences as stated by him in Exhibit 36. So friends, we will have to make and realize that we all need to wake up. We all need to dig into these 153 bungalows in Belgaum Cantonment. Only then we can somewhere reach their land records, any court cases, any judgments against them, because even if they are against us, they will harm you. If they are in favor of you, you may pick up these small pleadings into it. Like in this case, two major judgments, Ghaswala and Allahabad were discussed. Both of them have been countered, but the judge is making an observation that why the defendants did not bring records to the court so that the adjudication of this case could have been in a better position. So all these questions need to be answered. And finally the court orders, it is hereby declared that the resumption of the suit property bungalow number 59 is illegal and not binding on the plaintiff. The defendants do deliver possession of the suit premises to the plaintiff. The plaintiff do recover the amount of 2,936 8 annas towards the arrear of rent and damages for use of occupation of bungalow till 1957. The plaintiff is entitled to means profit at a rate of rupees 82 per month and 10 annas. So friends, even means profit was given in 1957. The plaintiff may recover the cost of the suit also from the defendants. So all I would request these bungalow owners in Belgaum, just go to the judicial record room, get this whole file photocopied, share it with me. This evidence, Exhibit 1 to 85 is so important, is so vital for Belgaum bungalow owners. I remember in 2011, when Miss Nancy shared these documents with me along with Mehta Committee report, I was surprised that the bungalow owner, Mr. Bandukwala, who was actually traveling with me with the other bungalow owner whom I will not like to name because now he envies me. He was so surprised that his bungalow in 2011 was reissued a resumption notice. At that time, I remember the way these bungalow owners were calling me, you are a family, you are a brother, you are thick skin. But there's so many things to make me feel as if without me they are nobody. And today these two people, and especially Mr. Bandukwala, has not even called me or talked to me since 2011. Our plight is just amazing. I am sick of all this. We bungalow owners don't want to talk to each other. We only talk when we are on fire. So anybody in Belgaum, I with folded hands would request you. There is another boy, Mr. Rajan Shetty, he does a lot of hard work under the current tables. I'll request these people. I will even request personally to Mr. Kore, dig into this case. Let's fish out all court cases of Belgaum Cantonment from 1947 onwards. Thank you guys. Again I am saying, We are old grants, never converted into new grants. Thank you.